go ahead and start. We still have people coming in, but I want to welcome everyone to our July advocacy meeting. We have two of our chapter members, the Arc of South Florida, Tonja Parra, and the Arc of Jacksonville, Sarah Sullivan. They are going to lead the discussion on pool trusts for people with IDD. We will send out a copy of the presentation to all attendees after the fact, and we will also place this on our YouTube channel. So I will be monitoring the chat. So if you have questions during, if you would put them in the chat, and then if we have time, we can open up later on for question and answers. So I will let Tonja and Sarah give a little brief info on their wonderful selves, and then they can go into their presentation.
Sure. Hi, everyone. My name is Sarah Sullivan, and I'm the Vice President of Advocacy and Family Support here at the Arc Jacksonville. Part of my responsibilities here are our Jacksonville Pool Trust, and I'm going to talk a little bit about what a pool trust is, but I also want Tonja, because she has been doing this far longer than I have, and really is in the know about pool trusts. I'll let her talk about her program down in South Florida.
Good afternoon, everyone. My name is Tonja Parra. I'm the Director of Trust Services here at the Arc South Florida. And I am going to kind of go over some of the ins and outs of pool trust today for you. Hopefully get some time to answer some questions. Sarah is going to go over the overview of how, what, when, that kind of thing. And then I'm going to actually talk to you a little bit more about specific uses and that kind of things that you can do with the pool trust. So the first portion will probably be a lot of Sarah, and then the second portion will probably be a lot of Tonja, but we'll probably bounce in and out of each other as well. Like Sarah said, I have been here a long time. I just passed the 30-year mark a couple of months ago. And so I've been doing this quite a while, and look forward to sharing, information with you and hopefully enlightening you to the use of these pools.
So just to kind of reiterate what Tonja just said, is that we can't really talk about pool trusts without talking about other kinds of special needs trusts, because a pool trust is a type of a special needs trust. So we're going to talk about that because a lot of times out in the community, you will hear the term special needs trust. And you might be like, what's that? You might hear first party, third party, self-settled, different terms, and they're all kind of talking about they're not all the same, but they may achieve kind of what you're looking for. And at the end of the day, it really has to do with what fits your particular situation, what your family situation is, and then you choose. So it's not uncommon for families to come and say, well, I spoke to this other family, or I have a friend, or whatever, or I spoke with my estate attorney who doesn't do special needs planning, and they said I need blah, blah, blah. And I'm kind of like, well, first of all, I'm not going to give you legal advice, but it really does depend on what fits your particular family's needs. We're also going to, obviously, after we talk about special needs trust and what's a pooled trust, we're also going to talk about ABLE accounts, because for smaller amounts of money, an ABLE account might be more affordable. But the responsibilities of managing an ABLE account might also be a detractor. So we're going to talk about how ABLE accounts differ from special needs trusts, and then how the special needs trusts differ from one another. So let's get started. So there are different kinds of trusts that are used in special needs planning. And you already heard me throw out a bunch of the terms like a giant word salad. So we're gonna kind of pick those apart. So a first party special needs trust is also called a self-settled special needs trust. And it is limited to people under the age of 65. and it is for disabled individuals who themselves have the money, whether it came from a personal injury settlement or whether it came from an inheritance that maybe didn't go directly to a trust, or it could be, for whatever reason, they have some extra money. And that is when you do a first party, and what first party means is that it's the disabled person's money, first party money. A third party special needs trust is what parents, caregivers, aunts, uncles, whomever, who want to provide for the future of their individual with a disability, for their future, and that's funded using somebody else's money. So the parents' money, the caregiver's money, the aunt, the uncle, whatever. It is not the money of the individual with a disability. So that is what a third party special needs trust is. Now, with a third party special needs trust, you can set that up during the caregiver's life, or oftentimes what will happen is something like a life insurance policy, or maybe an annuity or some kind of retirement funding source won't be available until the time of death of the person, the caregiver that's funding the third party trust. So a lot of times what will happen is a person will go into their estate planning attorney. They'll either create a will or they'll create a family trust, which is different. That's not a special needs trust, but they will have what they call a pour over provision to create a third party special needs trust. So for those people that say, I have a trust, if you haven't actually gotten an EIN or have gone beyond just having a paragraph in your will or your special needs trust that you've created at the time of creating your estate plan, you still have some steps to do, and those steps may not happen until after your death. So that's a planning consideration. A lot of people will think they've got all the boxes checked and they've got it all done. But a lot of times people don't understand, if they have a third party trust, that it's basically just the mechanism or the structure or the scaffolding or whatever you want to say. It is the structure for which to have a third party special needs trust, but it isn't actually created yet. Okay. So a pooled trust, which is what we're here to talk about today, is they're generally less expensive to set up. And depending on what kind of pooled trust it is, it could be first or third party. They are generally very stable as far as investment opportunities are. So, and it's also a great opportunity for people that don't have, millions and millions of dollars. Let's say somebody has 50,000, 100,000, 10,000, whatever they have. The pooled trust might actually be a really good option. Pooled trust can only be operated by nonprofit 501c3 operations. And that's why the Arc of South Florida and the Arc Jacksonville have pooled trusts. We are nonprofits. We serve people with IDDs. So the pooled trust was a really great vehicle for us to continue to serve the people that we serve, but also there is a benefit to the nonprofits that run the pooled trust. We'll talk about that in a minute. If it's a first party, I forgot to say this, with a first party trust, if it is the disabled individual's money, there is a mandatory Medicaid payback provision that must be in that first party trust in order for it to be recognized as a special needs trust. And generally, the Department of Children and Families have to review the terminology in those trusts and approve it in order for it to kind of stand muster. At the end of the life of the disabled individual, whatever's left in that trust goes back to Medicaid. With a third party trust, what's great about that is that if it's, it is the caregiver's money, in that trust document, you can say where you want that money to go at the time of the death of the individual with a disability. And so this is a great option for families that may have multiple siblings, and one sibling is the individual with a disability. They get the use of the money during their life, and then at the end of their life, The money then goes to whatever heirs that the originator of the trust want, where they want it to go. With a pooled trust, with the first party option, they usually have what they call a sub account. And so they take all of the participants in the pooled trust and they invest it in a pool. The sub account is always maintained separate. So for example, if you put $1,000 in the pooled trust, $1,000 is in your sub account. Nobody else can use that money. And it will grow, and it will grow kind of with the pool as the pool grows with investments. So there is usually an entity that does that division of what the dividends may be on those investments. So at the end of the life of the beneficiary of that trust, the money goes usually back to it can either go back to Medicaid or go back to the nonprofit. Usually in the trust documents, it will kind of explain the process. Here at the Arc Jacksonville, what we normally do is our board of directors serve as trustees. And at the time of the death of a beneficiary, we request that there be a board resolution on whether or not the trustees retain the money or whether it goes back to the Arc Jacksonville. We provide that to our trust administrator, which is a separate entity called FND. And then they release the money to the Arc Jacksonville. Or wherever, if it's Medicaid. So that is how the money goes from the trust to the nonprofit. And like I said before, there's an incentive for the nonprofits to operate the pooled trust. And that is the incentive for us, is that money, instead of going back to Medicaid, that money stays in the community where the people with intellectual and developmental disabilities live and get services. And a lot of people that set up trust feel very strongly that that is what they want to see happen. They don't necessarily want that money to go to Medicaid. They want it to stay in the community where their loved one lives, resides, and takes advantage of services. If it's a third-party trust, and I know that Tonja and I have done this before, so I kind of know what she's going to say about this, but we have a third-party trust option here at the Arc Jacksonville. And so if families want to do a third-party trust, it is a third-party pooled trust. So the money is still pooled, but the family members are the ones that are funding it. And if that's the case, it operates where it does still go to the other beneficiaries at the time of death of the individual, but there is a fee that the Arc retains for being the trust administrator for the many years that the third-party trust is in place. I need to mention a qualified income trust just because that's another term that gets bounced around. And it used to be, when I first started doing this work, I always thought a qualified income trust was for seniors that were trying to get into long-term care Medicaid. And that is the case in a lot of ways. But it's also for individuals that are working, that are making over the income limits for either Social Security, like SSI or SSD, or are making more than they can be to stay on the waiver. And these are people that might be pretty significantly disabled physically, but are able to work full time, but their level of care is so expensive that it far exceeds their ability to pay for it individually. So a qualified income trust is a really great vehicle. Our pooled trust can serve as a qualified income trust. So we do have several individuals that are working full-time, really need to keep those waiver services, and they are able to put that income into the pooled trust as the qualified income trust so that they can maintain their benefits. So I just wanted to kind of talk about those. That's kind of your basic, very basic 4 types of special needs trusts that we deal with the IDD population. So this is kind of a slide that talks about the differences. I know I've already kind of discussed it, but a third-party special needs trust can be established by anyone at any time, regardless of the beneficiary's age. Now, remember why that's significant is that if it's a first-party special needs trust, you have to be under the age of 65. And a first-party special needs trust has to be irrevocable, meaning you cannot change them once established. The pooled trust is also irrevocable. So that's kind of the nature of special needs trusts in general, is that they're irrevocable, meaning they cannot be changed. Sometimes when you're doing estate planning, if you're creating a family trust as part of your estate plan, that might be revocable, and that is not going to be suitable. So in that trust, you have to have secondary language that's going to satisfy Department of Children and Families. What DCF is looking for, especially with the first party trust, is that it's irrevocable and that money is going to come back to Medicaid at the time of death of the beneficiary. Okay. Third party trusts, they allow families to provide money to the disabled individual while keeping them eligible for benefits. The overarching reason for all special needs trusts, pooled trusts, first party, third party, qualified income trust, is to keep people eligible for their benefits. Okay. And then once they keep them eligible for benefits, they also have the ability to draw that money out to pay for things. Further on in a couple of slides, we're going to talk about what kind of things trust can pay for. And so it's not an unlimited thing, but I will say that pooled trusts are essential, even if it's a small amount of money that's put into a pooled trust, are essential to really improving the standard of living of your loved ones. It's really important to kind of look at all the different tools, financial tools that are out there, including pooled trusts. I have actually had very, very educated people, very sophisticated people come to me and say, well, I'll just disinherit my disabled child because that seems to be the easiest thing to do. No, don't do that. Don't do that, because you don't have to. You can utilize that third-party trust. You can open it during life. You can fund it during life. You don't have to fund it during life. You have all these different options. So you do not need to disinherit your loved one. And first-party special needs trusts, obviously we talked about including a Medicaid payback provision. We're also going to talk a little bit about ABLE accounts, and ABLE accounts do not have a mandatory Medicaid payback provision, but they do have a requirement at the end of life of a person with a disability that you alert Medicaid, and there is a possibility that Medicaid can come back in and take some of the money out of that ABLE trust. I know one of the things that they, first of all, ABLE accounts are a great tool. I oftentimes recommend ABLE plus a pooled trust, ABLE plus a special needs trust. So I'm not knocking them at all. I think it's a fabulous option and tool for people. But I think a lot of times people hear, oh, it's not a automatic Medicaid payback. Well, no, it's not. But you have to do this form and you have to send it to the state, and the state does have the ability, Medicaid, to come back and get that money at some point.
Hey, Sarah,
Yes.
real quick, before you segue anymore, you may have covered this in some discussion, but just to clarify. So the money that is left in a special needs trust on the beneficiary's death, does it go to Medicaid if the beneficiary was not on Medicaid?
I don't believe it does. So the whole reason there's a Medicaid payback provision is because that person is receiving Medicaid services. That's usually why you use a trust, is to qualify for benefits. And Tonja, I saw that you unmuted, if you want to jump in.
Yeah, I just wanted to say, we have no knowledge of what that Medicaid lien is at the time of the death of the individual. So the very first thing that we're going to do is we're going to reach out to our contacts there, and we're going to say, hey, John Smith passed away on this date. Is there a Medicaid lien? And they will tell us yes or no. So it's, they will know. And it's for the lifetime of the individual. So maybe they're not receiving Medicaid right this minute, but maybe at some point there was Medicaid being provided and there's a lien on those funds.
And I should say, in a pooled trust, it generally does not go back to Medicaid. In a pooled trust, generally it's retained by the nonprofit. I would say like 99.999% of the time it is retained by the nonprofit.
Well, and the reason, just to put this out there, the reason that is written in is that it's twofold. Number one, obviously, it does benefit all those, individuals living in the communities, other services, other 501c3s. It can do a lot of good in your community for our population. But the other reasoning is because of the way that pooled trusts are established and the fees that we receive for the enormous services that are provided for that fee, a lot of times we lose money, providing the service, and those funds help us kind of, I don't want to say recoup because it doesn't go into our, bank account, into the agency bank account. It goes into the residual, but it helps with that enormous cost of running a pooled trust.
I hope that does that answer your question, Dina? Okay. So pooled trusts, we're going to do a deeper dive on pooled trusts. So they're generally more affordable to set up. And the reason they're more affordable is you don't necessarily have to have an attorney, although we do suggest that people review it with an attorney if they want to. They actually sign something that says they had opportunity to review it. But generally it is not, what we're seeing here in our area is that an estate plan that includes a special needs trust is going to cost several $1,000s. Right now our pooled trust is $750. The price point might be different with Tonja, but I'm sure it's much less than what private attorneys are charging down in South Florida. Some of our attorneys in Florida, our attorneys in Jacksonville, are charging anywhere between $300 and $700 per hour for their fees. So this is a very affordable option. It also is what I call the set it and forget it option, in that you open it up, you've got somebody else managing it, you've got other trustees, you don't have to rely on family members or yourself to be the trustee. For people that are kind of busy doing caregiving or don't feel that they have the skill set to manage their own trust, or don't want to pay, a private entity, this is a really great option. The minimum deposit for a pooled trust sub-account is well below what a private trust company requires. And when I say that, for example, if you want to open a pooled trust with us, $10, right? $10 just to open it up, and then you can put money in it as you see fit throughout your lifetime. Or you can fund it all at the time of death. I mean, what's great is that it does have that kind of flexibility, and you only need a very minimal amount to open it up. And the person with a disability may create his or her own pooled trust sub-account. And it can also fill the gap between basic support and the needs and comfort of a beneficiary. So it's really great because it can be used on all different kinds of things. And we have actually a part of our sub account, our agreement, our joint, we call it the joinder agreement. Part of our trust agreement that we fill out with the people we serve basically says, what do you want to spend it on? We usually say be very broad because you never know what your needs are going to be in the future, but it's very broad on what you can and cannot spend it on. It's not necessary to find a suitable trustee because the board of directors of the nonprofit serve as the trustee, and the administrative expenses can be lower than those of a different kind of special needs trust. In addition to funding the special needs trust account through a will, it can also be designated as a beneficiary by a life insurance policy. So remember I said before, like, how do people fund these pooled trusts? You can actually, if you're a caregiver, you can fund the trust. You can name the pooled trust as a beneficiary for your life insurance. Any kind of account that has a designated beneficiary can name the pooled trust. So that's also a great feature. All right, so let's talk about ABLE accounts. I think they're great, and they've been available since 2015, so they're not quite 10 years old yet. So they're a relatively new thing on the scene. It is a tax-free savings and investments. If you have had a 529 plan, education plan for a child, and they have a disability that would qualify them for an ABLE account, you can actually convert that 529 college savings plan for an ABLE account, because they are kind of operated under the same federal legislation. It is tax-free savings in investment, so that is an incentive for an ABLE account. And it is generally disregarded when you're looking at eligibility. So remember when I said the reason for a special needs trust is to keep people eligible for benefits? ABLE account does the same thing, up to a limit. So for example, and this is going to probably create some head scratching, I think in Florida, the ABLE account limit, like how big the account can actually get, is over $400,000. However, if you're trying to stay eligible for benefits, you cannot go over 100,000. Okay, so a lot of people are probably gonna be like, well, that's not going to be a problem, but it is a problem for some people. So just so you know, your ABLE account can grow bigger than 100,000, but you don't want it to, because then Social Security is going to treat it as an asset. The IRS may come in and want you to pay taxes on it. So just so you know, it should not get bigger than that. And that's one of the limitations, right? Because a pooled trust can be as big as you want it to be. First or third party trust, as big as you want it to be. ABLE account really needs to be limited at $100,000. Also, you cannot plunk more than $18,000 in it annually. So similar to a 529 college savings plan, you are limited in how much you can put in it every year. So if you are, you can't set it up and just put $100,000 in, right? You can only put up $18,000 a year. ABLE accounts are by state. Each state is different in their requirements. So for example, in Florida, with the Florida ABLE, you go through ABLE United, you have to be a Florida resident. There are some other states that don't even have ABLE accounts at all. So then people might say, well, if I live in a state that has no ABLE account, what do I do? Well, I believe Ohio is one state. There are a couple of other states that don't require residency in the state to have an ABLE account. So you could, for example, live in Florida, but have an Ohio ABLE account, or you can have a Florida ABLE account. You have to have a qualifying disability prior to age 26. They were talking about expanding this. I'm not sure if that's happened, but for example, for APD, you have to have your disability before age 18. To get disabled adult child benefits of Social Security, you have to have your disability before age 22. For the ABLE account, age 26. So, you know, let's make it easy. Let's make 3 different ages for these different benefits. I love how they do this stuff, but for ABLE account, 26 is the magic number. You can only spend money from the account on qualified disability expenses. And those are supposed to be, what is the qualified disability expenses actually defined by Treasury regulations. But remember when I said this isn't even 10 years old? There isn't a lot of information on what is absolutely not a disability related expense. So they kind of give you guidelines on the website about what a disability related expense is, but you can't just go spend it indiscriminately on anything that you want. So you are kind of required to do that. You can have an ABLE Visa prepaid card. We use TrueLink for our pool trust. I believe TrueLink is also the card that they use for the Able account, and that TrueLink card is kind of like a prepaid card where you can't spend any more than what's on there. You have to transfer the money from the Able account to the card. And like I said, it has to be used for a disability related expense. You can't just go, crazy and on a spending spree that's not a disability related expense. There is no quote unquote Medicaid payback provision, but the account is subject to Medicaid estate recovery, which sounds deceptively, well, not deceptively, but it does sound like a Medicaid payback provision. So basically what happens is when a person that has an Able account dies, whoever's handling the estate has to fill out forms that basically alerts the state that there was an Able account, and then the state then has to affirmatively do something other than, so that's different from a first party special needs trust where there is a mandatory automatic Medicaid payback provision. Okay. So this is kind of a very quick list of what is a disability related expense: health, education, housing, transportation, legal fees. These are kind of what you would consider, basic kind of things that support people with an intellectual and developmental disability. So I always give this example because I love the Buddy Cruise. So shout out to Buddy Cruise. So let's say you had a person that wanted to go on a Buddy Cruise and they wanted to pay for it, their Able account. Totally fine. They absolutely need a companion to go with them on the Buddy Cruise. So they want to pay for their companion for the Buddy Cruise. Totally fine. They have 3 or 4 other family members that think the Buddy Cruise sounds like a really great idea and a lot of fun, and they also want it to be paid for the Able account. No. Okay, so do you see where the difference is? Person with a disability, Able account can pay for the cruise. Companion is necessary. It's a disability related expense. 5 companions that are family members, not so much. So 1 companion, person. So just so you have this idea that it just does it. It's not like a carte blanche, can use it on anything. And I'm sure there are other examples out there, but you really have to be careful. Another thing about the Able account is, hey, it's flexible, it's affordable. However, you are solely responsible for keeping track of those expenses. And if you get audited by the IRS or by Social Security, you have to provide proof, receipts, statements, whatever, that what you spent it on was disability related. So it's kind of one of those things where, with great freedom comes great responsibility or whatever. So you have the freedom with the Able account. It's a very liquid account. You can use it on a lot of different things. You've got this card that you can put stuff on. But at the end of the day, you are going to have to account for every dime that is in, every penny that is in the Able account. And I'm not saying you're going to get audited all the time, but if you do get audited, you could run into a problem if you haven't been a very good bookkeeper on what that stuff is spent on. So it's not the kind of thing where you have a debit card and you can run it through like anywhere, you want to go. It's the kind of thing where you really have to be on top of it. And you, the person, the account holder, is responsible for that. It's not a trustee. It's not a trust management company. It's not the board of directors. It is the individual who has the account. It's responsible for how that money is spent. So that's one of those things where you have this great freedom, you have this great independence, you have this great ability to have this pile of money kind of at your disposal, but you also have all the responsibility as well to make sure that you can account for that. And a comparison to a special needs trust to an Able account. I think we talked about eligibility. You have that 26-year age limit for Able account. It really can be any age, and really any person can set up a special needs trust depending on the type. Okay. The purpose are very similar in that you hold assets for people to protect their public benefits eligibility. And with the Able account, remember, they're really focusing on disability related expenses. So a special needs trust has a little bit more flexibility on what it can be spent on. Expenses, it can cover a wide range of expenses, including those that are meant to enhance the standard of living. And then for the ABLE account, it's, as we've talked about, it's limited to qualified disability expenses. Annual contribution limit, what's great about a special needs trust is that there's no limit. You can put millions and millions of dollars, you can put $10. And for an ABLE account, like I said before, it's $18,000. Now, those of you that have had an ABLE account for a while, that limit kind of goes up every year. $16,000, $17,000, $18,000 for 2024. That particular amount is tied to the federal real estate and gift tax exclusion. So expect it to change annually. Just a little bit, just a little smidge. So if you're wondering where do they get this arbitrary amount, it's not really arbitrary. It's tied to the annual estate and gift tax exclusion. So control and management, obviously with a trust, it requires professional management and a professional setup. And we talked about the cost involved in that. Even with a pooled trust, there is a cost to get it set up. With an ABLE account, you can set it up online, kind of like when you open up any kind of checking account, you can do that now online. And it's now actually they're giving, I think I was on the website, like a $50 incentive to sign up. So you almost get paid to set up an ABLE account. But like I said, along with setting that up, you also have all the responsibility for kind of tracking what is done.
Hey, Sarah.
Okay.
I have several questions. Some may have been answered, but I'll just go through them. Obviously, each state has different ABLE accounts. Can you have one in 2 different states as long as you meet the requirements? They're not contingent.
I believe you can only have one ABLE account at any given time.
One at least.
One ABLE account.
If you move, you have.
But you can have an ABLE. So if you move, so I actually had a client who had, I want to say they're living in Maryland, had an ABLE account in Ohio, and then moved to Florida. And they reached out to ABLE United, which is the Florida ABLE, and said, do I need to transfer this? And they said, no. But part of the reason is because in Ohio, you do not have to be a resident of the state. So if you're moving from Florida to another place, I would check with whether or not they have an ABLE account, and then kind of figure out, talk to the state where you're going to figure out what you need to do. But only one ABLE account at a time. They don't want people to be able to be like, oh, I've got this 100,000 here and this 100,000 there, and this 100,000
Well,
there.
remember, you've got to remember it's tax deferred. So the most they want you to do on an annual basis is 18,000, and that's where there's that cap. So they don't want them running from state to state, putting 18 here, 18 there, et cetera. We want to, that cap is important.
Right. And also I should say, if you've got multiple children with disabilities that would qualify for an ABLE account, each child can have an ABLE account. So it's not like it's one ABLE account per family. It's one ABLE account per individual with a disability. But the disability has to be diagnosed prior to age 26. For example, if you've worked your whole life and you're age 58 and you start taking your Social Security disability, you aren't able, even if you're disabled, you're not able to sign up for an ABLE account for yourself. But if you have a child under the age of 26 that has a diagnosed disability, and it's not limited to intellectual developmental disabilities, it's any disability. So if you've got a child that's disability under the age of 26, you can sign up for an ABLE account. If you have multiple children, you can have multiple ABLE accounts. Okay.
So here's a question. If a person with a disability has a special needs trust set up by a family member and the family member dies, even though there is a trustee, will the money have to go back to Medicaid for waiver services?
So what they're talking about is a third-party trust. I'm guessing. I'm guessing. All right. So based on the facts that you've presented to me, it sounds like they set up a third-party trust, and those third-party trusts do not have a Medicaid payback provision. What happens with those is the person that set up the trust, the person that's funding the trust, right? The family member that has just died, their money from wherever, from their estate funds that trust. But they also, when they created that trust, probably said where that trust money will go at the time of the disabled individual's death.
Right.
So it should be in the planning documents what happens to that money. It is the power of, it is the decision of whoever sets up that trust. But that money goes wherever that person says it goes at the time of death of the disabled individual. And
It
Tanya's
doesn't
going to add
matter
something.
who set it up. It matters on the funding source where the funds came from to fund it. And I agree with you, Sarah, based on that question, it sounds like a third party set it up. So even if that third party passes away, the trust itself was still funded by or landed in the third party pot.
Okay. It's only first party special needs trusts that have that mandatory Medicaid payback provision. So it's the disabled person, that's why they call it first party. It's the individual with a disability, it's their money funding that trust. And that's where there's a Medicaid payback provision. If it's a caregiver, a family member, whatever, and they set up a third party trust, any third party money can go into that trust and it does not go back to Medicaid at that point. Okay.
What kind of fees do annual trusts have, the pool trusts?
Tanya, I'm going to let you kind of talk about that because I've talked about how much it costs to set up and that kind of thing.
I can only tell you about in our particular agency, but our setup fee it's a one-time fee of $950, and then our annual fee that's charged on the anniversary date of whenever they joined is 2.85%. I will point out that our particular fee, that 2.85, includes in our investment, our outside investment manager, and it includes all of our CPA, tax preparation, all of those extra little things that have to be done. We don't charge. There are several pool trust companies throughout the state that do charge different amounts and charge extra for those things. There's a few that also charge a per check charge or that kind of thing. We don't do that. We don't have any maximum number of checks that can be written every month. So if you're shopping around for a pool trust administrator for something that you're looking for, those are very specific questions that you need to ask when they give you that number, when they say it's a percentage, because we're all percentage. All trustees throughout the state that I'm aware of are a percentage, but you do need to be very specific and say, what specifically does that cover?
Yeah, that is a very important question, is what does it cover? And also, if you are looking at a private special needs trust where you're doing it through an attorney, you want to ensure that trust language is run through the Department of Children and Families and approved. If it's a first party trust, you also need to determine who the trust, who's going to be managing the trust, and also if there's a minimum. Because there are some trust companies, a lot of times the financial institutions, banks, and they don't want anything less than $500,000 or $1 million or $3 million. So if you're not funding it at that level, even if you put this particular trust administrative company, they won't accept it because it doesn't meet their kind of threshold.
I would even add to that, Sarah, and this is something that not so much in the pool, but if you do an individual, like we talked very briefly about, I would even interview the trustees in advance, and I would ask them to read through it themselves to see if this is something they can live with. Here at Arc South Florida, we do administer individual special needs trusts, first and third parties, And I won't accept a trust that I have not read prior to signing. Okay, I do accept successor trustees, but again, before I accept, I will read through the entire document, because if there's wording in there that you as a trustee cannot do, or is totally, I mean, I'm not an attorney, never been to law school, don't want to go to law school, but I've read enough of these trusts throughout the years that if something's blatantly wrong, that's nothing that I'm going to put my agency in charge of. So you want to, reach out to your trustee, do your homework on trustees, have them, work with you, because it's very important. You're stuck with them for a long time.
Mhm. Right, we talked about them being, once you have a trust set up, it's more difficult to change it than it is to make decisions at the time that you're creating it. So let's talk a little bit specifically about full trust versus able accounts. And then I'm going to let Tonja continue talking about kind of the different options, and also maybe answer some questions. There's been some pool trusts in Florida in the news lately, and we want to allay any fears, people that might be on the call. So obviously we talked already that pooled trusts specifically are managed by nonprofits. It pools the resources for investment and management purposes, but each person has a sub account, and the amount that they put in and the dividends, the gains and losses that happen with those investments are, allocated based on the amount of money the person has in their sub account. The ownership and control, obviously with an able account, the account owner has full control over the funds, and can make withdrawals as needed. And with a pool trust, it's managed by a trustee or professional management company. So the beneficiaries don't directly control their funds. I usually tell people when they're coming, I try to set expectations that you're dealing with a trust management entity. And so that may affect the speed with which you receive your money. So if you're used to having a debit card that you can just run and get your money immediately, then a pooled trust may not be what you're looking for. But I will say that there's more safety, there's more oversight than would be with an able account. Eligibility, there's no age or disability onset requirement for a pooled trust. So it's even for people that don't have an intellectual or developmental disability. In fact, we have a lot of individuals have different kinds of disabilities that presented themselves. Remember my example a few minutes ago, if you're 58 years old, that kind of thing. If you need Medicaid and need to protect your benefits, but there's some other reason why you have too much money, a pool trust might be an option for you. Whereas you've got that age 26 requirement and a $100,000 limit with an able account. A pool trust can cover various expenses, recreation, anything that enhances standard of living, you can use a pool trust on. You can also limit it with the, how you write your joinder agreement. You can kind of limit what you spend it on. So also that trust management company does have oversight as to those kinds of expenses. So they do have the ability to say, no, we're not going to pay for that out of the trust. With able, you are limited to the qualified disability expenses. And I suspect that as the able account gets older, and the Treasury has regulations and maybe people get audited, that we're going to have a better idea in the future of what is and what is not a disability related expense. We're just not there yet. Cost and complexity, pooled trust, there is a professional setup. There is no DIY. I mean, you can do it yourself by going to the nonprofit that's running the pooled trust, but you can't just, do your own. And there are setup fees and annual fees, as Tonja talked about before. But the able account, you can do it yourself online with your laptop or your desktop or whatever. And with annual contribution limits, of course, a pooled trust, there are no specific limits. You can put in $1, you can put in, millions of dollars. But there is that annual contribution limit of 18,000 in 2024 for the ABLE account. So, and that's because of the tax deferred, nature of it. It's just a different kind of financial account, but they can actually work together. So I'm going to let Tonja talk a little bit about her program. This quote just wasn't related to pooled trust when I was like doing some research, but I'm like, oh, this totally fits. Wealth is the ability to fully experience life. In pooled trusts, special needs trusts, the full experience of life is something that is afforded when you have set aside money for a person with a disability. They've got their benefits, but they have this extra pot of money that can really kind of make their standard of living better. So I thought it was appropriate. I left it in. So Tonja, can you tell us a little bit about what you have, but tell us a little bit about your different products, because I kind of at the beginning said we have a first party and a third party, or a pooled option, and then a third party family pooled option. But tell us a little bit about Arc of South Florida.
Well, the Arc of South Florida has been doing this for since 1992. Believe it or not, we received our first individual special needs trust, and we started administering that single trust, and we've just grown through the years. I now have individual special needs trusts that are both third and first party. Our pool product, our pool program product, is a first party only. I currently do not offer a third party option when it comes to the pool. So that's kind of where we are with the offerings that we have. Dina, I saw a couple more questions come in that, I know I wanted to get to as many questions as possible. Is there something that somebody had there that I could expand
Let's
upon?
see. The 2.85 annual fee, the percentage, is that a flex amount or is that a set amount?
That's a set amount based on the balance in the account on the anniversary date.
Okay. Can real property be put into this trust, or is it just financial?
In our particular case, we do not put any real property into the pool program. However, on our individual special needs trust, I do have consumers and trusts that own property, individual houses, cars, etc.
Okay, and does the person who opens the pool trust name the trustee?
Yes, initially, yes. And they can even go as far as again, we're talking an individual. If they wrote their own trust, an individual, yes, they could name their trustee, and they can even name a successor trustee.
Okay, now, unlike an ABLE account, can the individual receive money from the trust each month or only as necessary?
What I do in those particular cases is we do, at the very beginning, we do a budget. And let's say some of the things that come into mind that immediately come into mind for individuals on a monthly basis is like a haircut, a gym membership,
Cable,
like that. So
streaming services. Yeah.
Cleaning, so exactly. If things like that, if it's in a budget format, then yes, we can set it up as a reoccurring payment to pay to not the individual, but to a third party that would allow them to have those funds to pay for those expenses. And then, of course, and this is where we always run into it, there are receipts required, obviously. But yes, it could be set up into a monthly budget and one check.
Okay, what about, since the trustee is the decision maker of what happens, do they have a responsibility or obligation to inform, I would imagine this is saying the individual, of what is going on with the assets in the trust?
In our particular case, we do reports on a quarterly basis. And I will provide those quarterly reports to anyone that the beneficiary and or grantor requests. So if the person that, let's say, grandma set it up for Johnny, okay, she's the grantor, Johnny is the beneficiary. If grandma wants reports, I'll send them to her. I can send them to Johnny if he's capable of understanding them. I've got several accounts where I have a brother that both his brother and sister want those reports, so I provide it to them on a quarterly basis. So it's really customizable.
And what?
And I should say, Dina, before, so with our pool trust, we have the pool trust where, so all of our pool trusts are managed by FND. So we do not do in our board of directors are the trustees. And that's a big difference between, I think Tonja has trusts that are like that, but she also has these other options that she's talking about. So if you were to come to Arc Jacksonville and fill out a joinder agreement to join our pool trust, the board of directors would be the trustees and the management company would be F&D. And the accounts, you could look at your account and have online access to that. And that's through KeyBank. So you have the option of getting your monthly, you would get like a monthly statement or have access to one online. But just so you understand that what Tonja's talking about with picking a trustee is a first party trust that's different from the pool trust with the joinder agreement. And our third, yeah.
And that's why I keep saying for our particular program, because we do things differently than you do it. You do it differently than, someone
the guardian trust. Yeah.
So we all kind of abide by the same rules and we have to follow the same regulations, but how we get there is kind of our business plan,
Right. And let me give you an example. I have a family that came in and fairly high asset parents. Dad had been in the banking business. They were actually inquiring, like, why would we want to have a pool trust? And they had already established a third party trust through their estate plan and knew that they wanted to know about like who was managing our investments and who did this, that, and the other. And so at the end of the day, they really felt like they wanted to keep it kind of like a family affair, right? So they wanted, they had the know-how and they had the desire and they wanted to have the control over it. And I said, maybe pool trust isn't your cup of tea, and that's okay. That's why I said at the beginning of the presentation, there is no one size fits all.
Exactly. And even with a pool versus an individual that comes in that's 3 years old and doesn't have any major medical concerns, that child can live to be 80, 90, 100 years old. And so your investment strategy for that individual may be completely different than someone a different pool or a different individual trust, maybe that's in their 60s. And with a pool trust, you don't really get that option to kind of customize it specifically around that individual. You're customizing it and you're basing it on a group.
We had a question about an EIN. Yes, they have EINs. The individual sub-accounts do not have individual EINs, but each trust has an EIN. If you have a first-party S&T, that should have its own EIN. The third-party trust should have its own EIN. So, and that's not something that automatically gets done. So when I told you, if you go to a private attorney and that private attorney drafts a trust or drafts the language to create a trust, which is more often than not what happens, whoever facilitates the funding of that trust may also have the responsibility of going and getting the EIN from the IRS. So just so you have an understanding, that's another kind of great thing with a pooled trust that's established, is that the pooled big trust has an EIN, and so if you are creating a jointer agreement, you don't have to worry about that. The third party trusts do have to have their own individual EIN. I hope that answers your question about EINs.
So I know that we're getting close to time, and we appreciate all the information, but I did want Tonja just to give a bird's eye view of the situation for those individuals that unfortunately were part of the trust that is going through some legal issues.
Yes. Well, first off, if you're in that group, my heart goes out to you. That is not the standards at which pooled trusts or any trust administrator at any level should be working at. But to give you just a brief oversight, this particular trust administration company really did everything underhandedly. They did everything kind of incestuously, and they, got these companies, in addition to the pool trust company here in the middle, they then got an HR company, and they got an investment company, and then they kind of intertwined them all together so that they could do what they did, which is not a good thing. For those of you that don't know what they did, what happened was that company here in the state of Florida decided that they were going to use the trust administration or the beneficiaries' money that they put into pooled accounts. They were going to make a loan on it. And so they made a loan to another one of this founding fathers' companies, and that has never been repaid. Currently, there is about $100 million missing. I did hear that there is a secondary not-for-profit that is now being looked into, also controlled by this same individual, and that there may be another $40,000 missing there. So there is, there was a lot of really horrific things that were going on. Currently, it's I want to say it's kind of at a standstill. When I say it's at a standstill, I don't think it's really at a standstill. I think there's a lot going on, but the information is not forthcoming. They are Attorney Moody with the state of Florida. She had a press conference several weeks ago that said that they were looking at theft and deception and fraudulent charges against this main individual. But I haven't really heard any more since that point in time. It's really kind of died off with what's out there. So I'm sure that there's a lot going on. There's several legislators that got involved in this, and I'm sure that they're working frantically behind the scenes. That's really the only thing I can tell you.
Yeah, so what kind of prompted all this is that the trust has filed for bankruptcy.
Well, yeah,
because of the actions of this individual who basically stole the money from the pool trust to loan it to another entity. And so
that he was in control of, that he was also in full control.
Right. So the pool trust filed for bankruptcy. The bankruptcy has its own trustee, which is a different kind of trustee altogether, but they have a person that's appointed by the federal bankruptcy court to kind of handle all of these particular issues. And so for those of you that may be involved in this particular trust, you should have received notice that from the trustee and the federal bankruptcy trustee and And I believe that they're bringing in a national pooled or special needs trust to kind of take over.
They're
So-
also doing full forensic accountings. I mean, there's a lot of that stuff going on. I just haven't heard any more local what's happening.
Word on the street, right?
Yeah.
When
Yeah.
it first broke, the Florida bar, we as ARC entities had discussions about it. There was a lot of news articles and things. So we just wanted to address it today because we're talking about pooled trust and we operate pooled trust. We are not them. They're just, keep an eye out because the more you're informed, the better choices you can make. But we wanted to provide those of you that either have pooled trust with us or are interested in signing up, that this is, pooled trusts are a really great tool for you or your loved one to really enhance their standard of living combined with other things like ABLE accounts or other kinds of things, it really can be a game changer as far as providing those needed things.
I did hear an interview just real briefly. I heard an interview with a mom from the Tampa Bay area where this is all going on. And this mom was just furious, as she should be. And she was talking about how this is horrendous and this never should have happened, and that we have to not have these kinds of trusts anymore. That's not the answer. I mean, these trusts are a vital role to our clients that need these vehicles for these funds. So just, throwing a net out there and saying that they're all bad is just really incorrect. And what I would encourage, if there's any parents or administrator, guardians, etc., out there listening, I would encourage you to do your homework, interview people that you're thinking about giving these funds to, talk to them, find out, where they're located, where do they do their banking, where do they do their investments, ask to speak to the investment advisor, ask these questions so that you are comfortable. If you wouldn't reach in your pocket and give $10 of your own money to the individual you're talking to, that's probably not the right person for you to invest or put your loved one's money with. So just talk to them, invest them in, and any trustee that doesn't want to take those calls and answer those questions probably isn't for you either.
Great advice. Well, we thank you so much, Tonja and Sarah, for taking the time. We'll have this presentation on our YouTube channel by the end of the week, and we will forward to all attendees Tonja and Sarah's contact information along with the presentation. So thank you all for joining.
Thank
Thank you, everyone.